My name is Lieutenant Koka Shao, and today my colleagues and I will be discussing commercial law, in particular commercial law in Zimbabwe. Now, the birth of commercial law was mainly influenced by the activities of merchants and guilds during the Middle Ages in order to protect their common interests, commercial activities. However, today we will be discussing the origins of Zimbabwean commercial law. And in order for us to do that, we'd have to go back to the roots of commercial law, which is the Cape of Good Hope, the roots of all Zimbabwean law. So Section 192 of the Constitution states that the law to be administered in the courts of Zimbabwe is the law that was used at the Cape of Good Hope. This was also the position in the old constitution, which mainly focused on that fact. And for us to understand commercial law, it is therefore pertinent for us to ask and understand the question, what was the law that was enforced at the Cape of Good Hope on 10 June 1891? And in what respect has the current legislation modified the law that was used at the Cape of Good Hope on 10 June 1891? And for us to understand that, my colleagues will take us back to Roman law, Roman Dutch law, English law, and then show us the position of the current law in Zimbabwe concerning commercial law. Now I'll let my friends take over and explain the rest.
Hello viewers, my name is Rutendo Chiwota. Just like what my co-counsel was saying, we are here to discuss on the origins of commercial law in Zimbabwe. Commercial law in Zimbabwe dates back to the Roman Dutch law, to the Roman law. So in order for us to understand the background, in order for us to understand the history of commercial law in Zimbabwe, it is important for us to discuss the origins, to discuss the history of Roman law. So I will take you through the history of Roman law. Now you would note that Roman law is in three phases. We have what we call the Republic, the early empire, and also the late empire. So I will take you through the Republic. Now the Republic, that was around 753 before Christ. The Republic was composed of three components. We have what we call the two executives, that was the consuls, the magistrates who replaced the kings. And we also have what we call the Senate. This was the advisory body that was responsible for giving advice. Then we also have what we call the House of Assembly. That was the body that was responsible for enacting legislation. So during this Republic period, you would note that there were two classes. That was the praetors and the plebiscites. The praetors were the ones who were very rich, and they were the wealthiest class, and they dominated the whole society. And we also have the plebiscites. These ones were very poor. They were economically and politically underprivileged, and they were oppressed by the praetors. As a result, there was a spirit of antagonism between the praetors and the plebiscites. So the tension between the praetors and the plebiscite reached its maximum to such an extent that there was no more peace in Rome. So as a result, this led to the enactment of the 12 tables. The 12 tables were enacted as a way of placing checks and balances on the praetors, that's those magistrates who replaced the king, those who were in power. So when the 12 tables were enacted, rules and regulations were enacted as a way of conducting, as a way of regulating the way of life, the transactions and also trade relations between the Romans and other nations. So you would note that because trade flourished during that era, because of the Romans' contact with other people, there was now the expansion of trade. So this led to the enactment of various doctrines as a way of conducting trade. One of the doctrines was what we call the contract stipulatio. The contract stipulatio, it was a doctrine where one would express his offer in the form of a question and the other one would express his unqualified acceptance. So you would note that the law of contract emanated from the 12 tables, in the sense that you would see that this aspect of offer and acceptance has its roots in the 12 tables, in the sense that the element of agreement where we have offer and acceptance has its root in the 12 tables. We also have another doctrine, another rule which was enacted, that was what we call the lex aquilae. The lex aquilae led to the introduction, or we can call it the foundation, of what we call the law of delict. This doctrine was enacted as a way of preventing unjustified enrichment over people. So you would also see that these laws that are in Zimbabwe, they have their roots in what we call the Roman law. Another doctrine, again, we have what we call the Republic of Ages. The Republic of Ages mainly focus on where one buys an item, and then you find out that there is a defect in that item, then you were required to ask for a refund or the repayment, or we can say a reduction in price. So this therefore takes us to the principle or the doctrine of actio redebitoria and actio quantum minori. So you would note that these principles that are applicable in commercial law have their roots in what? The Roman law. So what happened in this Roman times, there was now what we call civil wars. This tension between the praetors and the plebeians continued to such an extent that there was now civil wars, and as a result the magistrate, the Senate, and also the House of Assembly became insignificant, and they were replaced by what we call the emperors. And the emperor was an absolute monarch who concentrated power on himself to such an extent that he performed all the duties of the magistrate, the Senate, and this led to what we call the early empire. So my learned co-counsel is going to tell you more about what we call the early empire.
Hello viewers, my name is Yasha Msindo and I'm going to be presenting on the early empire. Around 731 BC, the republic collapsed due to civil wars, and Augustus became the first Roman emperor. He introduced the Antonian constitution, which led to the fusion of Roman laws and foreign laws. This constitution mainly focused on absolute ownership and the consequent right of vindication of property from a person's wrongful possession. It mainly focused on remedies rather than rights. In cases of fraud, they used actual dollar, and in other cases of cession, I'm now moving on to the late empire. This was during the reign of Justinian around 527 AD. He decided to codify the Roman law, and this was known as the Corpus Juris Civilis, which consisted of 4 parts, namely 1, the institutions, which were textbooks that were given to law students, which clearly explained the law. 2, the digesta, which were the Roman jurist opinions. 3, the codex, which were imperial legislation. And 4, the Manavele, which was promulgated after the formation of the codex. It should be noted that during this period, contracts could not be enforced unless the law had cleared them to be.
Hello guys, my name is Melody Tapera, and I'm going to talk to you about the present legal system in relation to commercial law. So what has been said before by my co-counsels about the historical and origins of commercial law will be no more of historical interest if they are not linked with existing legal system. What is important to note is that old law is good law, while some of it has to be replaced with new law. It is apparent for judges and legal practitioners to know where to look for the law when cases are brought to them. So classically, we have 4 sources of law, which are legislation, common law, authoritative text, and case law. So before we proceed to the 4 types of 4 sources of law we have to mention the key section in our constitution, which is section 192, which states that the law to be administered by our courts is the law on force on the effective date, the law on force on the Cape of Good Hope on 10th of June 1891. This provides a link between the law that is in use in Zimbabwe present day with the Roman law which was used at the Cape of Good Hope in SA. So I'll proceed to talk about legislation. Legislation is acts of parliament. So there are guiding principles which are related to the use of legislation. There are reservations. It is important to note that legislation which is enacted for a certain country should apply in that country and cannot apply in any other country. For instance, we cannot take a statute which is enforced in South Africa, which is not enacted in Zimbabwe, and apply it. So the second reservation is that legislation is governed by Section 2 of the Constitution, which says any act that is inconsistent with the Constitution is invalid to the extent of its inconsistency. The third reservation is that our statutes should contain plain meaning so as to avoid arguments. It is important to note that our statutes linked with the South African statutes, our wording are identical with the South African statutes. So in interpreting these statutes, reference should be made to South African statutes. The other source of law mentioned before is case law. In case law, we're talking about precedent. So when a judge makes a judgment, he gives his reasons for the judgment, which is the ratio decision, as opposed to the obiter dicta, which is the persuasive reasons, which makes him arrive at the decision he makes at the end. So when a court is approached with a case, a legal practitioner or a judge may make reference to the previous case. If the facts of the case are in line with the case decided before, the judge or a legal practitioner may make reference to that case. But if the facts of the case are different, then the case decided before can only be of persuasive value. So it is important to note that in Zimbabwe, the first preference is citing the cases which are decided before in Zimbabwe before going to refer to the cases used in SA. Where there is a gap in our Zimbabwean case laws, we opt to use the South African cases because our law is borrowed from the South Africa, which traces back to the Roman Dutch law my earlier colleagues were talking about. So I'm going to move on to subsidiary legislation. It is the acts in which the parliament, ministers and others delegate authority. But the subsidiary legislation has also a reservation because if left uncontrolled, they can be overburdened. Even in a small country like Zimbabwe, the volumes of subsidiary legislation become overburdened if they are not regulated. So the subsidiary legislation should not exceed the power given by its apparent legislation. So there are cases which state that if a subsidiary legislation goes far beyond more than what its apparent act authorizes, it is in subsidiary legislation will not be used if it conflicts with the apparent act, or if it is unreasonable, or if it goes beyond the purpose of the apparent act. So I'm going to move on to textbooks. It is important to know that modern writers make reference to writings of jurists from the Roman law, and our textbooks have traces of writings from Voigt and Creds. So it is important to note that Roman Dutch law and common law is still used in our textbooks, which are using in the present day in Zimbabwe. It is also important to note that the common law which is used in Zimbabwe, it is also borrowed from South Africa. It has been established before that there is a nexus between the textbooks in South Africa and the Roman Dutch law, as mentioned by the section 192, which states that in South Africa on the 10th of July 1891, the law enforced was the Roman Dutch law. So I'm going to move on to custom. Custom is only used when there is a certain trade or trade law or practice which cannot be replaced by either legislation, common law, or textbooks, which only custom can only regulate. So basically that's all about the sources of law we have here in Zimbabwe. And we can see the link between the laws which we are using and the Roman Dutch law. A certain English law is used in some instances, such as company law, but where they are in conflict with Roman Dutch law, as in cases of insolvency, they are not used.
So we've come to the conclusion of our presentation. As we have gathered from my colleagues in their presentation, we can safely say that historically, the law of commercial law can be traced from the 12 tables, which is merely codified Roman law. Later on at the Cape of Good Hope, English law was then introduced as part of the commercial law and remained dominant even after the Roman Dutch law was introduced, and then further on carried into Zimbabwe and used as part of our law here in Zimbabwe.